Hello, I'm Shannon Yavorski, a partner in Orrick, Harrington, and Sutcliffe's San Francisco office and co-head of our AI practice. Today I'm going to be talking about regulatory considerations in relation to AI. These are the Isaac Asimov's 3 rules of robotics. While Asimov's laws are a famous example of how to prevent robots from harming humans, they are not a comprehensive ethical framework. The laws can be difficult to apply in real-world scenarios, such as when a self-driving car must decide between avoiding harm to one person or greater harm to a group of people. But central to these principles is the idea that we need AI systems to avoid harm, and the emerging class of AI legislation has been struggling with the best way to do this. In this presentation, I'll talk about the rapidly evolving legislative landscape that applies to AI and how to effectively navigate these new and emerging rules. For all the hype out there about AI, one thing everyone agrees on is that regulation is important. Where the proverbial rubber meets the road is how to regulate effectively, prevent harm, mitigate economic disruption, like jobs lost to AI, and prevent misuse, like deepfakes, while at the same time encouraging and empowering the innovation, which is being called the Fourth Industrial Revolution. While there's an emerging landscape of AI-specific legislation, there are also a host of existing laws that already regulate AI. For example, consumer protection laws, including the FTC Act, prevent unfair and deceptive acts and practices. They apply to AI. Separately, employment laws prevent discrimination and can apply to AI-driven HR systems. In Europe, there's a whole range of digital strategy legislation, including the DMA, DSA, and GDPR, that are all relevant to AI. In the US, there are a few state AI laws, but over 600 new laws were proposed at the state level in the last year. So we can expect a wave of state AI legislation to continue over the next few years. In the US, due to the incoming shift in administration, we're unlikely to see federal AI law, so we can expect the US state AI laws to continue to proliferate. Globally, the EU AI Act, the first comprehensive AI legislation, is already in effect and is being copied conceptually by many jurisdictions around the world, including in places like Brazil. From a high level, countries are taking 2 different approaches: the unified legislation approach, like the EU AI Act, or softer approaches, like the EU, which has issued high-level guidance on AI. The balance to be struck is between regulation and innovation. In the US, many states have already passed AI laws. These laws often focus on consumer protection, like the laws in relation to deepfakes, or are focused on safety requirements. The emerging legislation falls into a few different buckets: transparency and disclosure requirements, like the chatbot laws that require companies to indicate to consumers when they're interacting with software and not a human; bias and fairness laws, which are regulations that require companies to mitigate algorithmic bias and ensure fairness; and privacy laws, restrictions on using personal data for AI training without consent; and finally, accountability, rules that specify which parties, so developers, deployers, or users, are liable for AI-related harms; and ethical standards, for example, guidelines for the use of AI in specific industries such as healthcare, education, and law enforcement. Washington, D.C. has been focused on AI regulation. For example, many federal agencies have issued statements indicating that they will regulate AI as it falls within their jurisdictional authority. There's already been regulatory enforcement. For example, the FTC has ordered algorithmic disgorgement, meaning the whole algorithm had to be deleted, in a few cases where personal data was used to develop AI models without appropriate user consent. Separately, the SEC has increasingly addressed the issue of AI washing, where companies make exaggerated or false claims about their use of artificial intelligence to attract investors or clients. This practice has come under scrutiny as it can mislead stakeholders about the capabilities or applications of AI in financial and business operations. The SEC's focus on AI washing highlights the importance of ensuring that claims about AI usage are truthful, clear, and substantiated. In addition, the DOJ recently updated the Evaluation of Corporate Compliance Programs, the ECCP, which prosecutors use to assess the effectiveness of a corporation's compliance program to address emerging AI risks. The eCCP, which was updated in September of 2024, now requires prosecutors to assess whether a company has adequately evaluated risks and developed controls associated with emerging technologies, such as AI. On the antitrust side of the house, the FTC and the Department of Justice, the two agencies responsible for enforcing the federal antitrust laws, have issued numerous public statements this year addressing the anti-competitive potential of AI. In February of 2023, the DOJ discussed the antitrust risks associated with companies' use of AI to aggregate data and collusively make decisions affecting pricing and output. The DOJ noted that several studies have shown that algorithms can lead to tacit or express collusion in the marketplace, potentially resulting in higher prices or, at a minimum, a softening of competition, and explained that while the DOJ is committed to ensuring that businesses can use AI to innovate and compete, they will also take action to prevent AI from being used to harm competition. In the EU AI Act, which is the first comprehensive AI law that is being echoed in legislation around the world, organizes AI systems based on their riskiness. Many countries have followed suit. The risk-based approach identifies 4 tiers of AI. First is prohibited AI, which includes things like social scoring. The second is high-risk AI for systems that could significantly impact safety or fundamental rights, like AI systems for credit scoring or employment. The third tier is limited risk, things like chatbots, where the key obligations are simply in relation to transparency. And finally, minimal risk systems, applications like spam filters or video games. Many countries around the world are following the EU in adopting risk-based frameworks. In the US, the Colorado AI Act follows the same pattern of putting AI into different risk buckets. How are companies responding? Companies are responding by building durable and flexible AI compliance programs built around key principles. They typically start with AI governance, that is, designating a person or committee that is primarily tasked with evaluating and overseeing AI adoption within an organization. We're seeing an emerging class of AI committees comprised of individuals from different parts of the company, including legal, compliance, marketing, and engineering, meet on a regular cadence to discuss AI adoption and deployment. Procurement is another area where we are seeing significant adaptation for AI. For example, companies are now including AI-specific questions in vendor questionnaires and negotiating specific contract terms for AI. For example, they're changing terms in relation to limitation of liability and indemnification provisions that help meet the new risks posed by AI. Separately, companies are developing and amending internal and external policies. We see a lot of internal AI use policies that outline how individuals within a company can use AI and which AI systems are permitted. I will leave you with this final set of high-level questions that can help you think about managing regulatory risk within your organization. Thanks for joining me today.